came across this news article from ZDNet about a lawsuit with Vizio regarding copyleft law. The Software Freedom Conservancy is suing Vizio over their SmartCast OS TV firmware, which supposedly contains BusyBox, U-Boot, Bash, Gawk, Tar, glibc, and FFmpeg, which are protected by GPL licenses. I'm guessing most of you are no stranger to the GNU General Public License and its variants. It's considered a viral license in the sense that if you use any GPL code in your project, your whole project then becomes tainted with the GPL, so to speak, and the whole thing must be free at that point. Big companies take strict measures to make sure they only use software with appropriate licensing, but it sounds like Vizio didn't. The lawsuit alleges that Vizio is using GPL tools and therefore must share the code when requested. But apparently Vizio is declining, and in the lawsuit, they're claiming that nobody has the right to ask for that except the copyright holders themselves. So my understanding is, in court, they're arguing that the only people who can ask for this is, for example, the author of Gawk or the authors of glibc. So it'll be interesting to see how this pans out. However, what's commonly understood is that anyone who purchases or owns the product has the right to ask. With the copyleft licenses, though, there's all kind of nuance. For example, if the firmware is updatable or permanent, can make a difference. If you dynamically link versus statically linking libraries, that can make a difference. Whether it's hosted on a server or you're releasing copies, these things can make differences, but Vizio's not making any kind of technical claim about why they are abiding by the GPL. They're simply saying, no, you don't have the right to ask. On Wikipedia, there is a page about some history of open source litigation. Specifically, there was a lawsuit about BusyBox, and the company in violation ended up settling and sharing the code. Since they settled, though, I don't think this counts as any kind of legal precedent, so it'll still be interesting to see how this pans out. Do you have any thoughts? Did you even hear about this lawsuit before? The last major open source lawsuit I remember was Oracle versus Google, fighting over whether Google could copy the Java API in their Android systems. I did not realize, though, that in April 2021, this year, the Supreme Court made a ruling on this case in a 6-2 decision that said Google's use of the Java APIs fell within fair use. Well, let me know what you think. Leave a comment, like, subscribe, and keep on hacking. Before you go, check out some of my products and services. Register and join our virtual hackerspace to get your own email account at devdungeon.com, a chat account, and SSH access to our Linux mainframe, which includes personal web space, Git storage, and other member-only perks. Join at my.devdungeon.com. Take my courses, Working with Binary Data in Python 3 and Deploy Django on Linux. Visit devdungeon.com/courses. Buy my book, Security with Go. Visit devdungeon.com/books. If you use Discord, Kathy is a fun chatbot for your server. Visit kathy.devdungeon.com. If you have a website, sign up with Apora to get notified if your site goes down. Visit apora.net. Bookmark devdungeon.com for reference and learning. Subscribe to the YouTube channel at youtube.com/devdungeon. Donate directly via PayPal at devdungeon.com/donate.